is another brilliant question, because now we have established that Functus Officio goes to protect findings and goes to protect discharge of a mandate. But what happens when a court has made a finding? Can that finding be available for review? The beauty in this question is asking at what are the different levels of review that is available to a judicial officer. First of all, it's important for us to understand what is judicial review. Because I am a believer that whatsoever you cannot define, you don't understand. And if you don't understand a thing, then you are limited at appreciating its performance and its function. So what is a judicial review? A judicial review is a constitutional safeguard that the Constitution puts in place so that we can check the discharge of public authority. Because authority is the most intoxicating of all things under the sun. So when we have given, if the Constitution has donated power, if the Constitution has donated authority, then silently with that authority subsequently, the Constitution also provides avenues of checking the discharge of that authority. Constitution will give and the Constitution will always take. So the taking aspect of a constitution happens in different ways. Another way is through checks and balance, that the Constitution will give this performance and the Constitution through another performance will check that authority. Let me demonstrate for us the triangle for checks and balance. You know, we have three arms of government, and in the triangular form of the three arms of government, we have always mistaken that one arm of government is at the apex. No, the triangular for the three arms of government is never seated. The triangular for three arms of government is always placed on the same surface. So it is not a triangular that is seated, but that triangular is placed on the same footing. So that means whether it's the judicial arm of government, the legislative arm of government, or the executive arm of government, they are all on the same frequency. They are all at the same wavelength. So no one has superiority over the other. That is what judicial arm, the three arms of government, and the checks and balances within them. That triangle is never seated. That triangle is always placed on the same footing, the same wavelength. So the executive arm has no superiority over the legislative arm. And the legislative arm has no superiority over the judicial arm. So all these arms are within the same wavelength. Having discharged that, and having told us the definition that I would want us to adopt from today of judicial review, which is a constitutional safeguard for the discharge of constitutional authority, what are the different avenues that now we can approach the subject matter of functus officio in the discharge of judicial authority? It is important to understand that the mere fact a competent court has found with finality, that finality does not stop that matter from being reviewed. Because sometimes we want to review, and the review is this: did the judge, faced with the questions of fact, you remember when we had said that in any matter there are two findings that any court must make. The first finding is the finding of questions of law. The questions of law are cast on stone. The questions of law will only move according to the questions of fact, according now to the interpretation of the person of the judge. That question of law is cast on stone. But the questions of fact, now these are constantly varying, and with their variations, then the law sometimes is invented to arrive at the movement of the questions of fact. So once a judge sitting in competent jurisdiction makes a finding, that finding is official, it is final as far as that judge is concerned. It is important for me to understand, for us to understand as well, that when we are looking at judicial review is only at superior courts. Subordinate courts have no luxury for judicial review. So judicial review will begin with High Court, the court of original jurisdiction. But when it comes to subordinate courts, one of the ways that we can review, but not necessarily reviewing, is by employing the facility of appeal. So the facility of appeal, in another way, operates in a way to check, to review the finding. So that is one of the ways. But there are two important ways of conducting judicial review at superior courts. One, you can apply for appeal to a superior court. So if it's a finding of the High Court, then you go to the Court of Appeal in Kenya for that Court of Appeal to check, to review the finding of a subordinate court, the High Court. So to that extent, the judges sitting at the Court of Appeal can review the findings of that lower court. It is also important to understand that High Court can check itself. So High Court, this is Court Ogwang. Court Ogwang sitting as High Court has made a finding. Court Otieno sitting at High Court can review the findings of Court Ogwang. So judicial review happens at that level of hierarchy, but also judicial review happens at the level of collegiality. We are colleagues, and as colleagues, we have the capacity to check ourselves, to check how we are demonstrating and discharging judicial authority. So review, in as much as it is functus officio, at the point of the individual judge, it is functus officio. But that judge who sat on that matter cannot review his own matter. A colleague within that and the same jurisdiction can check that judge, can check that finding. But the same judge, the moment you have made a pronouncement, that very moment, that pronouncement has exhausted, has emptied your authority on that matter. But your colleague can check that matter, or a superior court can check that matter. I hope I have attended to this question. The beauty of this question was for us to demonstrate the 2 points of judicial review, and even more importantly, for us to understand what is judicial review. Judicial review is a constitutional safeguards that the Constitution avails so that we can check the discharge of public authority. Authority is the most intoxicating of all elements. Power is intoxicating. They say that power corrupts, and absolute power corrupts absolutely. So the only way that the Constitution can check the levels and can manage the levels of being corrupted absolutely, the Constitution also contemplates checks and balances that we can manage discharge of that authority. My name is Ogwang, and I'm the principal at Franchise and Licensing Institute. I hope you derived value from how I addressed this question. And maybe you might have something that I might have left out. I would be interested to interact with you in the comment section. If you derived value from this content, I would humbly appeal, kindly consider following. Consider liking, sharing, and let's interact. Let's learn from each other. I'm merely giving my 2%. If my 2% mixes with your 8%, then we will arrive at 10%. My name is Ogwang, and I will see you in the next one. Until then, take care. God bless, and bye-bye.